Authorship, McHenry County. A few announcements before we get started. So first, we have an opening for a speaker next month. If anyone is interested, let us know. Also, we want to thank our sponsors. First and foremost, Follett for providing food in the space and helpful volunteers. And also the LaSalle Group for sponsoring our meetup.com fees, and they're a recurring firm. And with that, I'll hand it over to Mark. Thank you.
Hello, my name is Mark Whipple. You may have seen me on the meetup group. And by the way, the reason that the bio is 3 times longer than the description of the talk is that they just cut and pasted it from my blog. And I should have told them to cut it down so I didn't look quite so arrogant, but sorry. If you didn't see me or you don't remember, I am an intellectual property attorney. I am licensed in the state of Illinois, and I'm a registered patent practitioner, which means I can prosecute patents for the United States Patent and Trademark Office. I have been in the technology industry for my entire career. I was the general counsel of Meyerglass Design and Meyerglass Interactive, which were a content provision studio and a video game company, respectively. And then I was the general counsel of Incredible Technologies. If you've ever played Golden Tee or Silver Strike in a bar, a tavern, or an arcade, you know about Incredible Technologies. Even if you don't recognize the name, they are the world's most successful arcade game company. They also make regulated gaming products for casinos, such as video slot machines. My website is legalinspiration.com. I also write for indiegamerteam.com and a few other sites, like likelihoodofconfusion.com. The template that I use to make this up is the one that I use when I give talks like this at pop culture conventions, so it's a little irrelevant, it's not very formal, but as you can see, neither am I. Always have to say this, you know you're talking to a real lawyer when you hear this. Nothing I'm going to say tonight is legal advice. It's information for your entertainment and education only. The way you get legal advice is you hire a lawyer. I am for hire, again, business card's right over there. Seriously, not legal advice. You shouldn't take anything I say too much to heart, but you're always welcome to send me an email or say hi to me on Twitter. My DMs are open, and I do answer simple questions without making you become a client. Just don't ask me for legal advice, because I'll say that's legal advice. And that's really all I have to say about me. So, instead of trying to fill up my whole speaking time, I'm going to go relatively quickly. This presentation is relatively straightforward because I want to leave a lot of time at the end for you guys to ask me questions. And if you're not going to ask me questions, there are still some cookies left. So really, I get paid the same either way. But I know we're going to talk about copyrights, but I always see a lot of confusion. You know, people will say, I'm going to trademark that, and they mean I'm going to copyright it. I'm going to patent that, and they mean I'm going to trademark it, whatever. Intellectual property law mainly includes these things. There are other things like trade secrets that slip into them. And the really fun part is every aspect of intellectual property law is actually a subset of what we call antitrust law. Because intellectual property is basically a state-sanctioned trust or monopoly. That's actually where copyrights came from the statute of Anne, something in the 1500s. It was basically a way to give printers the exclusive right to print books and other periodicals so that nobody else would steal them. Patents. Patents protect inventions. Inventions are methods or machines or collections of matter. You know, things that do things that make things happen. Copyrights. Copyrights protect artistic expression. That includes computer programming and computer software code, which I don't have to tell a room full of programmers that computer code is an art form. Trademarks. Trademarks protect consumers by identifying the source of a good or service so that you know it will always be the same. Every time you buy a Jimmy John's sandwich, you know what kind of sandwich you're going to get. Jimmy John's is a trademark. Every time you buy a can of Budweiser beer, you know, if that's your thing, not judging, then you're going to get the same Budweiser experience. Now, who knows who actually owns Budweiser beer? Just a quick diversion. Who owns them?
Anheuser-Busch.
Who owns Anheuser-Busch? InBev. Wow, you guys are good. I never get this. Right. Most people don't go to the store, buy Budweiser, and say, I am going to buy some beer from a giant Dutch beverage conglomerate. They say, I'm going to buy some Budweiser beer. Belgian, sorry, not Dutch. So it doesn't matter that you don't know what the source is, it just matters that you know it's consistent. That's what trademarks are about. The right of publicity or privacy, which is the right to protect your likeness and identity. They can't take your face and stick it on a Wheaties box without giving you some money. That in the US is largely but not entirely preempted by copyrights. Copyrights are a federal law, privacy and publicity are state laws. Whenever federal law conflicts with state law, federal law always wins. But it does come up with copyrights a little bit, as we'll see shortly. And then moral rights is this weird European artsy thing that actually does get incorporated into American law under the theory of passing off, which is that you cannot sell somebody something other than what they are reasonably expecting to get. It's a little bit different from trademarks because there might not be a mark involved. The famous case is, who here is possibly a Monty Python fan in a room full of programmers? When Monty Python first licensed their television programs for sale in the US for display on ABC, ABC heavily edited them, and I bet you can guess why. Now, they did put Monty Python's trademark on it, so they couldn't say they had done anything wrong trademark, but it wasn't what Monty Python had made. They had changed the art. So they made the argument that this was passing off something that was Monty Python's original work, when in fact they had changed it. And it worked, and because of Monty Python, we now have, at least in the commercial sense, moral rights in the US. In Europe, they're much stronger, they do different things. But those are the three kinds. There are five. We're only going to talk about copyrights tonight, except to say that patents are almost entirely irrelevant to what you guys do. I do write software patents. I am actually extremely good at it, if I do say so myself. I've beaten 3 Alice rejections, if any of you know what that is, which usually makes patent lawyers say, wow, who did you bribe? But they protect novel inventions, which are devices or methods that could be relevant in video games or other software. If you come up with a really, really cool way of doing something algorithmically, maybe it's patentable. Computer hardware, obviously, is a very patentable invention. There's a bajillion computer hardware patents in the world. So if you work with hardware and software, they can merge together and form one invention. Pure software is very difficult, not impossible, but very difficult to patent. Design patents protect ornamental design. So if you make software with a user interface that is anything that's not bare bones, if it's got graphic elements, theoretically, you could get a design patent on your graphic interface. You may have heard of 2 small telecommunications companies called Apple and Samsung, who have spent the last 10 years in the output of a middle-sized country suing each other. Most of what they're suing each other is not over mechanical utility patents, they're suing about design patents, which most people don't know. That's what they're really arguing about. That's what most of that $500 million settlement was about. And then there are plant patents, and we're not even going to talk about those, because really, no.
So I have a question.
Shoot.
The patents, the big one I've heard of is the Amazon one-button purchase patent.
The one-click patent, yes.
One click.
Click to
So
buy.
is that the top or the middle?
That is the top, that is a utility patent on a method of doing business with a computer. Whether that patent would be able to be approved under current USPTO guidelines after the Alice decision is an open question. I don't think that anybody's tried to challenge it since the Alice decision came down. Who knows? I don't know how stringent Amazon is. Amazon and Google and many other companies, at least on paper, claim that they get a lot of the patents they do so that nobody else will get them, and that they either don't enforce them or that they license them on very liberal terms. To an extent, that is absolutely the case. There are several large tech companies that form public patent pools, and basically you just have to agree not to try to patent it out from under them, not to argue that their patents are invalid, a few other things. You don't have to give them any money. You can use the patents. In other industries, patent pools usually involve gigantic licensing payments. In regulated gaming, who here has ever been to a casino and used what's called ticket gaming or cashless gaming? Good. Room full of mathematicians and programmers? No. I was always afraid every time I went into a casino that my math professor from college would appear and just smack me. But anyway, that is a patent pool. Multiple companies develop the technology that goes into that. It's very valuable. You basically can't run a modern casino without it. So everybody who makes the slot machines goes to the patent pool and pays them a certain amount, Some of these companies make almost as much money when somebody else sells a slot machine as when they do, because they're getting that patent license. But, yes,
You mentioned the Alice decision.
Alice decision, yes.
Not familiar, could you briefly describe that?
No,
Okay.
no, I can't. It's been the subject of several, seminars and textbooks. But I will try to summarize it. Alice was a patent decision that made it all the way up to the Supreme Court. Whenever you hear about an intellectual property decision of any kind going up to the Supreme Court, prepare for panic and fury. The Supreme Court is made up of 9 poli-sci majors who are all in their 60s and 70s or older. They're all smarter and more accomplished than I will ever be. Let's get that right out front. But like I said, 9 septuagenarian poli-sci majors are in charge of the major incentive system for our technological civilization. There are issues. Anyway, Alice was a case where a company had tried to patent a method, and the company had a patent that they tried to enforce. Another company said this patent is unenforceable because to get a patent, you have to have an invention that has 3 qualities. It has to be novel, it has to be unobvious, and it has to be useful. It also has to fit within what's called patentable subject matter. You can't just patent any old thing. You have to patent something that fits within what the patent statute says is patentable. What I have started to call algorithms, the basic procedure of I am here, I want to get here. I have a limited, very high number, say I have a programming language. I have this information, I want to process it, I want to get this result. The programming language, in practical terms, I could come up with an infinite number of ways to do it, because I could just do things and undo them a million times. But in practical terms, there's only so many ways to get there. Algorithmically speaking, from let's form a process to get from here to there, there's only so many ways, there's not very many efficient ways to get there. And what Alice is about, essentially, is when is something a patentable method, and when is it a mere series of steps that is not patentable subject matter? As far as how you tell the difference, again, millions of words have been written on this in the 2.5 years, I think, since Alice came down. And it is about to go back up into the appeals courts for another round. At first, the patent office went, okay, software patents, nope, get out. All of you, out of the pool, everybody. Then a lot of software manufacturers and other lobbyists said, hey, wait a minute, methods are patentable, it says so in the statute, this is a method, I happen to execute it with a computer. And the patent office eased up a little bit. Now people are claiming they've eased up too much, we're going to go through the appellate courts again. Nothing is ever settled in law. So that's Alice in a nutshell, is when is my method, and a program is simply an implementation of a method using a formal language. When is it actually patentable subject matter, and when is it just, this is what you do when you want that to happen? Anyway, on to copyrights. Copyrights protect original artistic works that have been fixed in a tangible medium of expression. That last bit is more important than you might think. There was a famous case in Chicago a few years ago where somebody tried to copyright a flower garden. Not a picture of a flower garden, but a flower garden. And the court said, no, flower gardens are ephemeral, that is not fixed. No copyright for you. Go take a picture, you can copyright the picture. So, I'm just going to hit a few of these high points. The US is almost unique in that we have a registration system for copyrights. And for a while there was an open question about whether you had to register a copyright before you could sue somebody for infringement. The Supreme Court, for once, there was fury, but almost no panic. Recently, within the last 3 months, ruled no. The rule is you have to have a registration certificate. Then you can, that's like your admission ticket to the courthouse. They're usually very easy to get. The only real problem is that unless you pay an $800 expedited fee, which will get you your registration certificate in 10 days, they take 6 to 9 months, if not longer, to get. So if you're a small entity, a solo practitioner, something like that, you have a copyright, you can send DMCA takedown notices, you can send cease and desist letters, you can ask people to enter into licenses with you, but you can't actually sue them without the certificate, and the certificate either takes $800 or 9 months to get. That's not as bad, in my opinion, as it might be, because if you can't come up with $800 for the certificate, you don't even want to know what it's going to cost you to get me to the courthouse. It's a lot more than $800, I am sad to say. But anyway, we literally just found that out. So you can't sue anybody without the certificate. For practical purposes, and if you want to spend enough money, copyrights are enforceable worldwide. There are multiple international copyright treaties, which require most industrial countries to honor copyrights granted by other treaty holders, other treaty members. So if somebody takes one of your apps and puts it up on the German Android App Store or whatever, you can sue them. You don't have to go to Germany, and they can't say, oh, well, we're in Germany, you have an American copyright, buzz off. No, you can absolutely go after them. You're gonna have to hire a lawyer in Germany and do some other things, but you can't. So just because somebody's in another country, and that goes for you guys too, nobody in this room would ever, of course, use somebody else's work without permission and a proper license. But for people who might, just because they're in another country doesn't mean they can't sue you in America. Electronic media does count as a tangible medium. Sometimes people ask me that question. It's not an inherently stupid question. Most people find it obvious, but yes, your hard drive, your flash drive, all that's tangible. Once you type out the code, you hit save, boom, it's fixed. It's good. Copyright is actually a bundle of rights. It's not one right, and you can assign, you can sell, you can license those rights independently. If any of you are musicians, you know that you need multiple kinds of rights in order to perform, record, and sell music. Music is a weird, strange beast in that respect, even for copyrights, but there's the performing right and there's the reproduction right. Performance just means I can perform it in public. If you don't have a copyright license, you can't perform somebody else's copyrighted work. The reproduction right means to make copies. You might be able to perform and say, oh, here, I have a performance license. Did you get a recording license? No, then you can't record it and sell copies. You can perform it all you want, can't make copies. So distribution and the right to make derivative works, which is huge in the software industry in particular because code reuse is basically a religious principle for most programmers. So when you take code from somebody else's application and put it in your own, you are making part of your application a derivative work. You need a copyright license. This is more of a pop culture thing, but by the way, don't mail yourself things, please. The thing where you put it in an envelope and you mail it to yourself and keep it sealed, don't do that. A judge will laugh at you. I'm not kidding. And this is something to always remember about copyright. Copyright is a right of exclusion. I don't have to have a reason to stop you using my copyright. You have to have a reason that I can't stop once I have a copyright. Now, the burden is on you once I can show that you've infringed my copyright to show why I shouldn't be able to punish you somehow. Which is important because there are no copyright cops, just like there are no patent cops and no trademark cops. The only person who can enforce a copyright is the copyright holder. There is a small exception for criminal copyright stuff. It's not criminal copyright stuff, trust me. You will know if it's criminal copyright stuff. Other than that, only you, the holder of copyright, can enforce it. All right. Now we're starting to get into details. Authorship and ownership. The copyright in a protected work originally belongs to the person or persons who created the work. Individual creators are always referred to as authors, no matter what the work is. It could be a sculpture, it could be a painting, it could be music. We always call the person who created it an author in the law. That's the term that's always used in the statute. I mean, if you go into court and you say, I'm the musician who wrote that, or I'm the sculptor, the judge will know what you mean. It's fine. But we always call them authors in license agreements. Once the copyright vests in the person who created it, the only way it can change owners is by a statutorily authorized method. Copyright Act, we're going to get to this again, overrides all private contracts. Either you are in accord with its requirements or you are not. If you try to assign a copyright and you don't do it in a way that the statute says you have to, your assignment is null and void. It is unenforceable. It does not exist so far as the law is concerned. It's very, very, very easy to write a compliant copyright license or assignment. But people still get it wrong. And again, I don't have to tell a bunch of programmers how how creative people are about finding ways to do easy things completely wrong. Do you have a question?
Oh, no.
Okay.
It's just, sorry.
Sorry, your hand up.
I was thinking though.
That's okay too. For the most part, it has to be written and it has to be signed. Of course, there's a million exceptions, which we're not going to get into, but basically, if you don't have a written, signed copyright assignment, assume that you have no assignment at all. That is not true of a license. Here's the difference between a license and an assignment. An assignment says, I own this, it's mine forever, unless I give it to somebody else. A license says, this is mine, but you can use it. You can use it in the ways that the license says you can use it. And I could just say to you, here's this library that I wrote. I could hand it to you on a flash drive with no license or anything on it. Here you go, here's this library I wrote. Feel free to put it in your own projects. It's all good. You don't have to credit me anything. That is a perfectly valid software license. You know what cancels that software license though? I changed my mind. No, you can't. License gone. Now again, question of fact, if I had said you can use it forever, that'd be a different story. But I didn't say that. I said you could use it. I didn't say for how long or exactly how. So, assignments are usually better, but on the other hand, sometimes you just want to license stuff because then you can divvy it up more. I can license it to you, and you, and you, and you. And I can license it to you in Germany, and you in Russia, and you in India. And, I can divvy up my pie a million billion ways, as long as I retain ownership. It's very different. You can assign part of a copyright, but once you own some part of a copyright, we're going to get to that, it's very hard to control what other people who also own it can do. Copyrights can be partially or fully assigned. Here's 50% of my copyright in a written, signed, assignment document. You own half of it, I own half of it. Or, you wrote a program, I wrote part of it. We were sitting across from each other. Hey, I'm going to do this. Hey, I'm going to do that. We wrote an app. Who owns the app? Who owns the app? Hey, multiple authors. Single work can have any number of authors for practical purposes. It's usually limited to 2. It could be, like a script for The Simpsons. It could have 10 co-authors. 10 people were sitting in that room, all throwing out lines. An author is someone who created part of the original creative work. And here's an example that I made up for programmers. I tell you, I need an evaluation routine. I want it to take this data. I want it to put it through these steps. I want it to kick out this result. Yes, no, maybe. Go write it. You may not be an author. If you just do that, you use standard expressions from a formal language that we both knew you were going to use. Because you didn't create anything. Basically, you wrote down what I said. You just wrote it down in really, really badly spelled type. So, I'm sorry, I keep using you for the example. I got to move this. So, maybe or maybe not. It's a question of fact. If we start arguing about whether you're an author or not, the only person who knows is the judge. Because there's nothing in the law that says, oh, in music you may have heard of something called the 8-bar rule. There is no 8-bar rule. There is no 500-word rule. There is no nothing rule. People have successfully sued for copyright infringements on 6 lines from the refrain of a song, 6 words from the refrain of a song. People have unsuccessfully sued for copyright infringement for including the entire work in another work in a very abbreviated fashion. For example, putting a sculptural work in a movie. The whole thing is there. In fact, the camera even pans around it, but it's on the screen for 5 seconds in its natural environment. It was a mobile for over a baby's crib is the one I'm thinking of. 2-hour-long movie. The court said, nah, not enough. No copyright infringement. So, it's always a question of fact as to whether something is an infringement. Here's another big one. Any co-author can license the entirety of a copyrighted work, and by that, any co-owner. So if you assign your part, then whoever you assigned it to gets the right. You and I jointly wrote an app, 50-50, let's say. Apple comes to you and says, hey, we want to license that app. We don't just want to put it on the store, we want to buy it. You can say, hey, Apple, great. Here you go. Non-exclusive license. I come along, I don't like Apple. I don't like their aesthetic. I don't. Too bad. I have nothing to say about it. If you're a co-owner, you can license it. The only thing you can't do is you can't give an exclusive license without my permission, because then I can't use my company. But you can license to whoever you want, I can license to whoever I want. And even though we did it half and half, it doesn't really matter. If you cross the threshold to become an author at all, you have the same rights I do. The law does not distinguish between contribution levels. No. I wrote one subroutine in your gigantic app. Am I a co-author? Is it integrated? Does the app not work without that subroutine? Guess what? I can license it to whoever I want. You can't stop me. You do have the right to an accounting. So you sold it to Apple. We're the co-owners. Whatever you get, I get half. And I have the right to make you give me an accountant, to let me audit you, essentially, to make sure I get half. My 100-line subroutine in your 500,000-line app, I licensed it to Apple. You licensed it. Actually, let's say you licensed it to Apple. Whatever you get, I get half. And I can audit you to make sure I'm getting my half. So, you can see, really important to keep track of that. Because once somebody crosses that threshold into being an author, they have a tremendous amount of power over the work, regardless of what anybody else says about it, regardless of their level of contribution. Once they've got a piece of it, the whole work is theirs to play with. So, raises a very important question. Who is an author? The author of the work, we already talked about the fact that it's the person who contributes, original creative work. The author of the work, for legal purposes, and by author I mean the first owner in this context, is the natural person, a human being, or persons who created it, unless it was a work for hire. The only way a corporate entity, a company, an LLC, a partnership can be an author is if it was a work for hire. If it's a work for hire, the author, and the sole author, by the way, it is not a joint authorship between the natural persons and the hirer, is the person or entity who hired the person who created it. So, if my, Silly Apps Inc. hires you, says write me an app, we otherwise qualify, and we're going to get to that in a minute, that it's a work for hire, and I go to file a copyright registration, author, Silly Apps Inc. You, John Smith, I'm sorry, I'm terrible with names, by the way. He can tell you. Say your name's John Smith. John Smith, co-author? Silly Apps Inc. Me. It's mine. I'm the author. I own it. I didn't get, this isn't in here, because computer software, it's probably not going to be an issue most of the time. But by the way, one reason that's super important in many arts is that the Copyright Act allows for someone to take back an original author, to take back their work several decades into the thing's term. The famous case that was going around for quite some time was the DC Comics character Superman. DC Comics claimed that it was a work for hire. The heirs of Jerry Siegel and Joe Shuster, who created Superman, said, no, it was not. You licensed it, we assigned it to you, whatever. It's been however many years. We're taking Superman back, one of the most valuable intellectual properties in the world. And they could have pulled the whole thing out from under DC at the stroke of a pen. Well, eventually they settled. We've seen this in music a lot because the windows are starting to open for what a lot of people would consider like the classic rock, the first really big, long, music with legs that's still in commercials today. I mean, the Beatles, the Rolling Stones, people like that. Their windows are starting to open, and they're starting to be able to go to record labels and say, "I'm taking my copyright back on, incredibly valuable songs and other artworks." We're going to see litigation about this for the next 30 years. But if you are doing other kinds of art, and there's no reason a computer program couldn't do that. It's just that, 35 to 45 years from now, is anybody going to care about the code you wrote to the point where you're willing to spend a lot of money on me to go and harass them to get you the Copyright Act? It seems unlikely. No offense, you're all brilliant, but it just seems unlikely.
What's that time frame? Is it 50 years?
It depends on a couple of different things. It is usually at least 35 years after the work was created. So, it's decades. but the windows are starting to open. And some authors, especially musicians whose record labels, as record labels are wont to do, handle things very fast and loose, it is now finally coming back to bite them. Because the way they paid royalties, the way they paid for things, indicates that these were not works for hire. And that is finally coming back. You know, what comes around goes around, goes around, comes around, and it's coming around. That's one of the reasons why it's hugely important whether something is a work for hire, because if it's a work for hire, that window doesn't open, because you never own the copyright. The artist, you know, the human being, never owned it in the first place. There's nothing for them to take back. So, this is really important, and I have written somewhere between 10 and 30 at a random guess software development agreements for every person in this room. I have written a lot of software agreements. And this is the great heresy of copyright in software development. How many people here have ever signed an actual software development agreement? Did you see the words work for hire in there? It's a lot. Because the Copyright Act only allows certain kinds of works to be work for hire. A work is not one of the kinds of works in statute. It literally can't be a work for hire no matter whether you're an employee or whether the written agreements may say it's work for hire, and I'm as guilty of this as any highly experienced software development attorney because all of my agreements always say that. You know, if you ask me to take it out, I'd take it out in a heartbeat. I don't care about it because it's not enforceable. It's not illegal for me to put it in there. You know, I can ask for whatever I want. If I go up to a judge and I say, this is work for hire, it says work for hire, and he's like, is it one of the 9? Oh, no. Then get out of my court. It's not a work for hire. So, again, I think this is, all right, I don't know what's wrong with this. Two ways, not mutually exclusive in that you can do either. Can't really do both, but you can do one or the other. You don't have to do both. A work prepared for an employee within the scope of their employment. See that within the scope there, why it's bold and italic? You guys are programmers. You go to work, the boss says, write me a program to do X. That's literally what your check is for. Most of what you write is probably within the scope of your employment. I go to work, I'm an attorney. I create a little database to keep track of regulatory compliance requirements. It is not within the scope of an attorney's employment to write software. That is not a work for hire. Suppose they hired you to do, a certain kind of development. They hired you to write, stuff in C++ or whatever. You're a developer of certain kinds of stuff in C++. And then the boss says, hey, we need a little database to keep track of stuff. We're too cheap to pay for version tracking, although now there's GitHub, so who does? But back in the day, people paid big money for version tracking. Write us a little version tracking database, will you? They didn't hire you to write version tracking databases, they hired you to write C++ software. Is that a work for hire because it's in the scope of your employment? Heck if I know, let's go ask the judge. I'd take that to a judge. I wouldn't promise you I'd win, but I'd take it to a judge. Okay, suppose you're not an actual employee, and a lot of software development gets done by small houses, individuals, especially content providers, people who do graphics and music and stuff like that, but especially coders, people who go to coders and say, hey, write me a library. People who do video slot machines and gambling devices often buy libraries and math and pay tables from special houses. That's all they do is make pay tables. It has to be specially ordered or commissioned. Can't be like an ongoing thing. Every month we want X. Subject to a written agreement identifying, this is where those words are important, because if you do qualify, but the words work for hire aren't in there, even if everything else is okay, it's still not a work for hire. It has to say work for hire. And it has to be one of these things, these 9 things. If it is not one of these 9 things, it does not matter what the contract says. It does not matter whether it was specially commissioned. None of that matters. It's not one of these 9 things, it is not a work for hire, and unless the contract also contains valid assignment or licensing language, they have no right to use it whatsoever. Now, there's something called an implied license, which is, if I give you 10 grand to write a software library for me, and you deliver the library to me, and it turns out that I said it was work for hire and it wasn't, I still have some rights. There's some equitable principles there. This is, people don't just randomly write checks to buy libraries. So you're not home free, but you're in a very, very advantageous bargaining position. So, now given that a computer program can actually be anything that you want it to be, but these are the things. The contribution to a collective work is a gigantic app or a website, say, with lots of pieces from lots of different people, a collective work. If you give me just the right facts, I would take that to a judge, but by and large, no, because usually a collective work means a bunch of works otherwise independently copyrightable. And the classic example is an anthology of short stories. You're gonna do an anthology. You're gonna write an anthology about computer programmers and their lives. And I said, would you write me a little essay about computer programmers? You write me one, and you write me one, and it's gonna be a work for hire, okay? I probably own that. But if I pull your library out of the website, all that will happen is something will stop working. And it's probably not good for anything else, at least not without extensive modification. Is that a collective work? Probably not. Part of a motion picture, other audiovisual work. This is a trap. Video games are audiovisual works. Most other computer software is not. For example, a multimedia encyclopedia, back when we had those, is not. Audiovisual works have to have narrative. Video games have narrative, encyclopedias do not. A documentary, about a multimedia documentary, maybe. Video games, definitely. In fact, it's right in the Copyright Office's circular on registering video games. They're audiovisual works. Translation. Translating something between computer languages probably doesn't count. I don't know of any court cases. I guess it could happen. Supplementary work, don't worry about what that is, no. Compilation, yeah, don't worry about what that is, no. Instructional text, maybe, probably not. A test, probably not. Answer material for a test, probably not. Or an atlas, probably not. So really, these two are your only hope. If you're a video game programmer, you got something to hang your hat on. Otherwise, long, long road to hope. Probably won't work. So, most computer software is not capable by law of being a work for hire.
What year was that statute written?
The last major change to the copyright statute in this regard was in 1976.
So that was like a lot pre.
Yeah. Right in my flowchart. I had a flowchart. Sorry. So anyway, this turned into a flowchart. If it's on the next slide, I bet it is. I just probably forgot to delete this. Here we go, flowcharts. Flowcharts are much better. All right, computer software work for hire. Was it literally your job to create software of the type in question? Yes. Did you work for hire? No. Was there a written agreement specifying it was work for hire? And is one of these statutorily specified types of work? Yes. Maybe work for hire. No, it is not a work for hire. Period. All right. I have a young child. I talk like this. The copyright belongs to the persons who wrote it. Now, there may be some equitable licensing issues, all kinds of reasons why somebody else might have a right to use it in the absence of a written agreement, but who owns it? Persons who created it. Period. End of story. Commission content for larger works. This is what we were talking about before, shoving stuff into your things. Here's why computer code as code can't be a work for hire. Computer code is classified as a literary work. Literary works are not in that list. Collective works are, and literary works can be part of collective works, but literary works as literary works can't be. A block of computer code authored by a single person or group of persons who are not employees in and of itself can't be a work for hire, period. Amen. World without it. Does not matter what the development agreement, work order, whatever it says, private contracts can't override the Copyright Act. The scope of what can be works for hire is broad and complex. But we already talked about this a little bit. Unless you're making a computer game, the odds that if you're making something computer related that's an audiovisual work are very bad. If you are making a computer game, then maybe the content and or the game is an audiovisual work, maybe. Pretty unlikely that a computer program is a collective work within the meaning of the act. It's not impossible, it's very unlikely. Therefore, never rely on a work for hire theory. If you guys are doing development for other larger people who are hiring you to do this stuff, that's great for you. It means your negotiating position is a lot stronger than you may have realized. If you're project managers or you're working for big companies who are buying stuff from little guys, you need to always be aware of that. You need to interface with your legal people and say, this really weird guy in a Cthulhu shirt told me that just because it says work for hire doesn't mean it is. And if they just look at you and say it says work for hire, then you need to go to your boss and tell them we need a new order. Because that is unacceptable. Just because it says work for hire means nothing. So, always get an assignment agreement or a license prepared by a copyright attorney. All right, so I'm going to stop here and take questions. I do have a little more stuff if you guys are just going to sit there, but I wanted to leave lots of time so we can talk because people usually have great questions. Yes?
So earlier you said something about when copyright vests. When we create a work, when do we own the copyright?
The copyright comes into existence, and the question was, when do you own the copyright when you create a work? The copyright comes into existence at the moment the work is fixed in a tangible form of expression, tangible medium of expression. Now, if your development environment has autosave, arguably you're creating new copyrighted works every time the autosave kicks in. But at worst, you've written copyrightable code. You hit save, copyright now exists. Can't sue on it until you get your certificate. Copyright exists, you can file DMCA notices, you could license it, you could assign it, you could do all kinds of things. Did that answer your question?
Yes.
Okay. More questions? Hit me.
Yeah. How vague for number one with the, or point number one for the work for hire for the terms of employment? How vague is that? So if I get hired to work on a website and they ask me to build a mobile app, does that break that?
That is an excellent question. The question is, how broad is it to be an employee? What is under the scope of employment requirement for work for hire? That is largely a question of fact, which means that we don't know until we take it to a judge and a jury, and they say, okay, the statute says you have to be an employee, this has to be within the scope. You hired to do this, your educational background is that. Is this something, and we're going to bring in expert witnesses. You're going to bring in a witness, I'm going to bring in a witness. Says, oh no, mobile apps have nothing to do with website development. My expert's going to say, of course they do. Everybody integrates mobile apps into their website environment. And then who does the jury believe, or who does the judge believe? It is something narrower than the Illinois definition of an employee. I suspect that most, if not all of you, actually at some point, if you are an employee, have been an employee in the state of Illinois. Illinois has one of the broadest definitions of employee. Basically, if you're an employee, nobody who's a company or an employer listen to this. If you go to the Department of Labor or the Employment Services in Illinois and say, they didn't pay me correctly, they didn't pay me overtime, they didn't give me breaks, whatever. They say I'm a contractor, I say I'm an employee, you're an employee. Because that's what the ruling is going to be. The state of Illinois is just extremely liberal in that regard. This is a union pro-worker state. Just is. In other states, Texas said, much narrower. Well, okay, yeah, he did kind of tell you what to do, and he told you what time you had to be in the office, but, you could take breaks whenever you wanted, you didn't get docked if you didn't show up. You're not an employee, even though in Illinois you would so totally be an employee that we'd already be writing a check. Those are labor definitions, is kind of where I was going with this. As far as whether you are an employee for the purpose of copyright, it's almost very tautological. Do you get a regular check? Were you hired? If you have an employment agreement, that's fantastic, but even if you don't. Was it your job to come in here, sit at that desk in front of that computer, and write this kind of code? Or draw these kind of pictures, or whatever it was that is claimed that you were an employee? And then we argue How far away from that, that's the first question. It's usually pretty straightforward. Did you get a regular check? Did they take taxes out? We all do it for benefits, whatever. Yeah, you're gonna pay. Then we look at what do you normally do? What did they tell you you were gonna do when they hired you? And what is this thing? How far apart are they? And there's no bright line rule. There's nothing in the statute that says, this many steps away and boom, the chain is broken. You're no longer an employee for purpose. It's no longer within your scope of your employment to create those things. We go to a judge. We go to a jury. Almost any copyright attorney can listen to a story and give you an answer with a very high degree of confidence. We never guarantee anything, but if you come to me with your story and you give me the particulars, I will give you a response with a very high degree of confidence, whether or not your employer is going to be able to claim the support. Yes?
So what does a good employment agreement do to essentially give the employer the rights to that work? If we're a software developer. Wow! And why aren't software developers just suing their employees all the time?
A lot of times because it is very expensive.
Yeah.
Not a lot of times because it is very uncertain. And a lot of times because that is really not very good for your career. Let's be practical. But if it's a big enough thing or you've been mistreated enough, then yeah, you should totally do it. As far as what's in your employment agreement, the employment agreement should be both as specific and as vague as possible. It should specifically say, I am hiring you to create things, to create copyrighted materials of the following kinds, but then instead of super narrow definitions of computer software that can bite you, that come back and say, well, how would a reasonable person have understood what the scope of their employment was? It's going to be somewhere in the middle. Again, I've probably written 10 of those agreements or more for every person in this room. It certainly can be done to a high degree of confidence. I'm very confident that my former employers and my current clients who use agreements that I've drafted and hire professional programmers, that they own the work that's produced by those programmers. But they say, hey, you guarantee this? No, I guarantee nothing. Both because even the law doesn't have those bright lines, and because jury's going to do what a jury's going to do, and hard cases make bad law. And the poor programmer who was cruelly mistreated, and they didn't pay him overtime, and that's a whole other subject we aren't even going to get into because it's way outside the scope of what I'm talking about, of whether programmers are exempt employees or not. And the answer that I usually give to that, most people don't like, but it's certainly something that comes up, and it happens all the time. I mean, just in the U.S. alone, a nation of 300 and some million people, 120 million people in the workforce, you'd be surprised how often it comes up that what an employer who thought they owned somebody's work product turns out that they don't.
Yeah, going on.
Oh, I think you was first. Then we'll.
Okay.
Yeah. No, you're okay.
Yeah, sorry.
Oh, no, I didn't see it. Yeah, kind of going along with that line, suppose, as an author, you had created a work, and then outside of the company, before you even were employed.
Yep.
And then you came into the company, and as a course of your employment, they wanted to go and have you create kind of like a derivative work of that.
Mm-hmm.
Do they own that now?
Maybe. I've actually had that exact thing happen with an employer of mine. They literally, somebody who was an independent developer, they hired them as an employee and bought the independent product that they had developed and were actively marketing. When you come in with your software, the first thing you're going to do is you're going to assign me that software. Lock, stock, and barrel. Now it's mine. Then you're going to sign my employment agreement that says your job, for which you are handsomely paid, is to write derivative works of the software that you sold, which now belongs to me.
But kind of the key is that assignment.
But without that paperwork, who knows what could happen. And then you got a question.
Yeah, you mentioned audio, visual work, games essentially, and you mentioned narrative. So what if it's what is something that's like a sandbox game that has no narrative kind of classed as? I mean, does it fall under
The
that?
code The underlying code is a literary work, and it is always copyrightable. Original computer code is always copyrightable, whether or not it's part of a game or any other form of audiovisual work. We only care about audiovisual works, A, because there might be some different licensing rules, and B, because we might ask the work for hire question. But as far as how much narrative does a game need to be an audiovisual work? Not very much. Tetris is an audiovisual work.
Okay.
And in fact, that's not even close to the line. So, not a lot. You know, games basically, even a puzzle game is get from here to here. Here is a jumble of weirdly shaped blocks, and here is solid lines. That's still, you know, a journey. Now, then of course you might say, well, but you know, writing a letter in Word is going from a blank file to a file full of stuff, and that's a journey. Well, you know, we could talk about that all night. But basically, if it's a game, you know, especially if it has music and graphics and just some kind of sequential go from here to get here and become part of a story, even if the story is very, very simple, it probably qualifies as an audiovisual work. Which means, by the way, that when you write, you know, especially a big AAA title, the people who write AAA titles like Gears of War or World of Warcraft, things like that, they're filing 3, 4, 10 copyright registrations in regard to every single one of those games. One for the soundtrack, one for the static art pieces as a collection, you know, one for the computer code itself. So yeah, it has a lot of different copyrighted protectable works in it. That's an excellent question. It's one that, you know, from my point of view, is really important because I've always worked, you know, since I graduated from law school in Birmingham, I have always had at least one client who was a video game producer. I've never not been a video game client. I've done a lot of other stuff, but I've always done. Yes?
So what about code that, let's say, decrypts something?
Mm-hmm.
Like,
That's a munition.
so for example, I'm familiar with the DCSS code.
Mm-hmm.
So what was that all, how does the plaintiff prevail in that? If I write, the authors of DCSS wrote a copyrightable work, how can someone say you can't write a literary work and have standing?
Well, that's really hard to answer. Again, it's heavily fact dependent. And I think that copyright for computer software, again, potential company employers, don't listen to this, is probably a little bit too broad. Because, you know, we were talking before about, you know, I have this data, say, and I want to process it and arrive at this result. There's only so many ways to do that in a formal language, like C++ or whatever. The mere algorithmic incorporation, you know, embodiment of that series of steps is arguably very, very lightly protected by copyright. And this is something that we didn't talk about, by the way. Copyright infringement requires copying. So if I say to you, you know, write me a library, you know, a 300-line library to take this input and kick out this processed variable. And then I say to you, write me a library, and I say, give you exactly the same spec. But you don't know each other, you have nothing to do with each other, neither of you ever see the other one's library. Odds are good, especially if it's a very small program, that your code will be almost indistinguishable. It will be very, very similar. That's called parallel development, or contemporaneous development. There's lots of different phrases that we use for it. You have a copyright, and you have a copyright. He takes your code and copies it. He takes your code and copies it. You can sue him. You can sue him. You cannot sue him. You cannot sue him, and you can't sue him because he didn't copy you, and he didn't copy you. He copied him, and he came up with exactly the same code because he was trying to do exactly the same thing, which we would expect. So when you're dealing with computer software code and you say, how is this not protectable? Or how is it protected? That's one of the questions that often doesn't get asked, and it's really important from a legal perspective. It's not like a patent or a trademark. Patents and trademarks can be accidentally infringed. It happens all the time. All the time. I have a patent on, my little whiz gig. You've never seen my whiz gigs. You don't know that I make them. You know nothing about them. You make a whiz gig. You're trying to solve the same problem I did. You have the same, the same original inspiration, and you come up with this new thing. You start selling your whiz gigs. I can sue the bejesus out of you. Copyrights, they just don't work that way. So, but now the question is, when do those 300-line expected to be nearly identical things diverge enough that it's impossible? That you say, oh, no, I wrote it all myself. No, it's 10,000 lines and they're byte for byte identical. You can claim, and if you can convince the judge and the jury that you didn't copy me, you're home free. But it's going to be really hard to convince somebody that you created, 100,000 kilobytes of identical code by accident. With a procedural generator, it becomes less improbable. So I think procedural generation of all kinds of copyrights code, all kinds of code is going to really mess with copyright, as well as procedural generation of all kinds of things. Like if anybody here is a gamer, if you've ever heard of a game called No Man's Sky. Who owns the copyright in the artistic works showing the planets in No Man's Sky? If you're not familiar with it, it's a space exploration game, and every planet you land on is procedurally generated. In your instance of the game, once a planet is generated by the game, it'll always be there. You can go back and forth to it. But if you go into my copy of the game, it won't be there. I'll have totally different ones. And there's not a library in there. It's just generating them from random parameters. And some of them are very beautiful. They have all this lovely scenery, and there's aliens, and all kinds of things. Who owns the copyright then? Who created it? That's an actively questioned topic in the field of copyright law. Because, in a sense, the literal answer is the machine who made it. But machines can't be copyright authors. Neither can monkeys, if you saw that case. But it's a question. My answer is, until they fix the copyright statute, it's still the person who wrote the procedural generator. Because the planet is merely the ultimate expression of the code they wrote. A lot of lawyers do not like that answer. But in any event, it's a real problem. Yes?
You really made me think about something that's related to that is, because you said for it to be a copyright infringement, I had to have actually copied it.
Yep.
For example, I have a website that generates some patterns similar to this world, and there are actually competition courses for this dog agility sport I'm involved in.
Mm-hmm.
And so you can imagine there's jumps, and dogs go over jumps in certain orders. But the layout of the jumps is always the same, but it's easy to write software that will generate many permutations of paths.
Mm-hmm.
And someone could say, well, I saw that same permutation at a competition last week. You have violated the copyright, but it sounds like it's unlikely that I have, because it was programmatically generated, and if I had not seen that course ever, it wouldn't. It would be
Copying
unlikely.
requires access, by the way. It's impossible logically, obviously, to prove a negative. But if you can convince a jury that you never had the opportunity to access the allegedly infringed work, you're home free. Because you can't copy something you've never interacted with. So yeah, if you can say, here's my procedural generator. Now, if they come back and say, you stole my procedural generation code, we're back where we started.
Right.
But if you can show that it was not, if you can convince the jury that didn't happen, you're home free. Because copyright requires copying. Now, does that mean that if, on one side is you and on the other side is the American Kennel Club, that they can't just lawyer you to death?
Well, yeah.
That is a completely separate and very sad question, which I find highly objectionable. But the answer is, they're going to come in with their copyright certificate, and it's going to be on you to prove that you didn't infringe. Now, if you have a lawyer who knows what they're doing, you'll be okay, but you're going to spend money. And that's the sad part. And a lot of people just like, screw this, I don't have this kind of money. Lawsuits are incredibly invasive in your life. They're draining. The only thing worse than winning a lawsuit is losing a lawsuit. So it's a question of how much energy you want to devote to it. But yeah, it's something that is on here. I didn't get into it. By the way, I don't know exactly how we are for time.
We have plenty of time.
Okay. Because another thing that comes up a lot is fair use, and you know, in the best house tradition, it's never fair use. But once you get into that, the question of how much is it protectable, how much can you use it, they're all questions of fact. The reason I bring it up is, like fair use, once they have the copyright certificate, the burden is on you, because now you are defending yourself, and you don't want to be defending yourself. Fair use in particular is a defense that means you're basically admitting you did infringe, and now you're trying to show why you shouldn't be punished for it. Yes?
So, so when you have like let's say you have an app on the App Store, and somebody steals your design, rebuilding it in a different language, rebuilding it in a different way, that's not necessarily copyright, that's more of the design patent that they...
Well, when you say design is a very ambiguous word.
Yeah.
For instance, it is extremely common as app developers, especially game app developers now, for you to put out a game app, you know, let's say it involves throwing birds at big stacks of rocks and trying to knock them down onto pigs, just to pick some random example. And it starts getting some numbers, gets some traction, and all of a sudden, 18 studios from everywhere, from the Ukraine to Shenzhen to everywhere, now all of a sudden people are throwing guinea pigs at. Guinea pigs is still too close. They're throwing angry puppies at giant stacks of wood to try and knock down horrible cats. The idea is the thing. And this is something, again, we didn't get into this. How do you protect an idea? The answer is you don't. Ideas are not protectable. Inventions are protectable by patent. Artistic embodiments are protectable by copyright. And ornamental designs are protectable by design patent. But I had that idea. Sorry, where's your patent, where's your copyright, where's your design patent? So the idea of throwing X at Y to annoy Z, totally unprotectable. Now, did they reuse your assets? Because people will literally, and again, you guys probably, many of you know this, they will literally just reuse your assets, just glonk them right out of your app and stick them in their own. Now they've stolen digital content that's protected by copyright. They stole your music, they stole your graphics. Or they use a name that's too close to yours and they're causing a likelihood of confusion. They're not infringing on your trademark.
How is stealing your assets not a derivative work?
It is.
Oh, okay.
Well, I mean, it's not a derivative work if they literally steal it. This is not derivative, it's just the work.
What if they
They're
steal,
infringing the copyright.
if they steal like one sprite and then they create their own game?
Right.
Yeah.
Then the new game is a derivative work, and we argue about if it's close enough to count. So yeah, that comes up all the time. And once that happens, we're talking to the judge, we're sending takedown notices, we're complaining to the App Store or the Android Play Store or the Google Play Store or whatever. And then we see who listens to us. Yes?
Are there any misconceptions about what you need to do as far as putting a notice in source code or on a splash screen? Is it just to make yourself feel good, or is it...
No, that's an excellent question. When copyright, especially international copyrights, were more modernized, it used to be a really big deal. How many of you have seen Night of the Living Dead, the original one? Do you know that movie is no longer in copyright? You know why? Because the distributor cut the copyright notices off the front frames of the movie before they shipped out all the cuts.
Huh.
And back then, no copyright notice, no copyright. It is no longer required to put any form of copyright notice on a copyrighted work, because the copyright comes into existence at the moment the work is fixed. However, if you do put a copyright notice on the work, it is much more difficult for anybody who literally copies it, especially if they're dumb enough not to take your copyright notice out, to argue accidental or inadvertent copyright infringement, which means it's easier to get certain kinds of damages from. So it's still a really good idea, but it's not required. It doesn't mean you can't enforce your copyright. What I think, especially now with the Supreme Court decision, it just came down. It's called Fourth Estate. There's a thing on my blog about it. Is that people don't understand how crucial it is to register your copyrights as soon as you can. We didn't talk about this, we're going to now, it's really important. You can always enforce a valid copyright until the term is up. That's the only limit, the term is up. But if you don't register the copyright before the infringement occurs, the US, this is the carrot part of that stick. In the US, if you registered copyright before the infringement occurred, and there's some other twiddlies that we won't get into, but basically that's it. You can ask for what are called statutory damages, is the first thing. That means, you stole my app. How many did you sell? Well, we only sold 1,000. We may be part of Tencent and we're worth billions, but our particular horrible copy only sold 1,000. We made $12.50. I don't care. I registered it. I'm eligible for statutory damages, $250 to $750 per infringement. I don't have to prove your profits up. I don't have to prove anything. It doesn't matter how much you spent. It doesn't matter what your net, your get, or your gross, anything is. I can ask for that instead. The other thing that is huge, if you registered it before the infringement occurred, you can ask, and you may get, it's not a guarantee, but you may get your fees and costs, which means you aren't paying me, they are paying. You spend $25,000 to get them into court. Turns out they only sold 12 copies. Your damages, don't even cover my parking. But they have to pay your fees and costs. So you get the $12.50, and I get the $20,000. And we both get a check from them. And everybody's happy except them. And good riddance. So those are the two big reasons. There's other really good reasons, but those are the two big ones. And the third one we already did talk about, which is you can't actually sue anybody until you have your certificate. So if you have it when the infringement occurs, you can go right to here is the draft of a complaint that I plan to file on Monday. Where is my check? Cease and or desist. Anyway, so that to me is the big thing that a lot of people don't know. It is extremely simple to register copyrights. You do it online. You set up an account. I offer, and I'm not trying to turn this into an advertising thing for me, but I have a consultation deal that I offer where basically you give me $100, you get an hour and a half of my time to talk about whatever you want. And in that hour and a half, if you show me how to file a copyright registration, I will happily show you how to do it. I'm always going to suggest, as will any attorney, and not just because we like money, that if you can, you have us do it. Because there's always the potential for something weird in any given situation, or at least talk to us about it, about the particular work that you're registering. But if you're registering code, if you're registering your apps, especially if they're game apps or other visual works, it's very simple. Once you have somebody walk you through it once or twice, you can do it yourself. You ship an app a week, guess what? It's $55 a week, to register each and every copyright. You're fine. It also, by the way, can help you when you're arguing with an app store or another distributor or publisher. You can say, I have a copyright certificate for this work. That is an illegal thing because it puts a lot more teeth in your takedown too, because now they're going to be liable too. You may not be able to sue the division of the week that Tencent created for illicit app stores this week, but you can sue Apple, you can sue Google. You know right where they are. They've got gobs of money. So it's very, very helpful. Yes?
So with the registration, social elements of process, it's always ongoing, right? At what point do I say, oh, I should pay my $55 or whatever it is?
That's an excellent question. The question is, if my software is ongoing development, how often should I register it? The flip, short, and not entirely terrible heuristic is you should definitely try to register it every time a number on the left side of the decimal point changes. As far as when a number on the right side of the decimal point changes, that's up to you. Like if you're Apple and you're going from system 10.5 to 10.6, then yes, we register the new system. If you did a bunch of bug fixes, but the game still plays the same way, the app still works the same way to scan electronic components or whatever it is your app does, maybe not. It's again, it's $55. You think, am I 55 bucks worth enough invested into this version upgrade that if somehow whatever I change is the only thing that somebody actually steals, is that worth 55 bucks to me to be able to tell them to knock it off? That's the short answer. The long answer is, you come and talk to me and you tell me exactly what you changed and whether or not you're likely to change more stuff in the future and what the difference is to the marketplace, and you make a decision. But their super, super rough rule of thumb is right side yes, left side yes, right side no. And then you had a question too, or somebody did, right next to
Well,
you.
so about registering, say you have a website with photography on it, register every photograph you upload to your personal website?
Oh boy, photographs. I used to be a photographer. Photographs are a weird beast. If they are unpublished, and don't ask me what published is, because that's like another 15 minutes just of whether something's published or not. It is not as simple as it sounds. It doesn't just mean you showed it to somebody. It doesn't just mean you put it on a website. If photographs are unpublished, they can be filed in a collection, and there is, for practical terms, no limit to the number of individual photographs you can put into one collection and file as. I literally have a registration certificate for unpublished photographs by Mark Whipple, 2006. Every photograph I took that I care about in 2006 that I hadn't already published, I put on one CD and I mailed it to the Copyright Office and I paid $55 and I got a certificate. They're all protected. If they're published, you can still file collections of them, but they have to be. There are some size limits as far as how many can be in there, and they have to be related in a certain way sometimes. But do you have to do individual photographs? No, you do not. For a photographer or another kind of artist, especially if you can control what publishes and doesn't publish, there is a 90-day window in that limit, that time limit on when you can sue somebody for infringement. So suppose I create the work, I publish it. A week later, somebody infringes it. I haven't registered it yet. But if I register it within 90 days of when it was published, it counts. So what I tell professional photographers especially is every 89 days, I want you to file a copyright registration for all of your unpublished works. That is very common legal advice in the photography industry. I know a couple of other specialist photography attorneys who tell their clients the exact same thing. And it would go for people who do music or other kinds of art. Apps probably doesn't work so well, but you see the idea. So unpublished works can be published as large collections. Published works can be published as smaller collections or have to be published individually. Have to be registered individually. Yes?
Yeah, say I had a website in VB and I translated to C#. I had a copyright on the VB site. Do I need to do a new copyright for the C# site?
The answer is it depends. If you completely rewrote it from scratch, especially if you did put a lot of work into it, VB to C to C#, is that what you said?
Yeah.
VB to C# that's a lot of work.
Yeah.
You might very well say, you know what, 55 bucks. I'm filing this. If I could show that those code bases were significantly equivalent, I might be able to argue that stealing one is stealing the other. I don't think it would go over very well. I'd argue it if that was all I had. I don't know that it would. So yeah, especially if it's a major rewrite.
Yeah.
I think I would definitely file a new one. Even if the front end is practically indistinguishable. If everything in the back is brand new, I'd register it.
Okay.
Yes.
So if I'm an employee and I do a side project that I want ownership of, it sounds like from what you're saying, that's not too difficult to obtain.
It happens all the So, although what you do want to look out for is your employment agreement and or your employee handbook. Because a lot of them say that anything you create belongs to us. Is that enforceable? Maybe. It's a long jump. Did you use your work computer? Have you been working on it, when you were supposed to be working on company time? Story changes. But, you go home every night, you work on your Throwing Birds at Pigs app, and it sells $1 million. Your employer says, I may have hired you to do DBA, but your contract says that every computer program you create is mine. There are actually cases on that. It's not going to work. It's very unlikely to work. Talk to an attorney, but it's very unlikely to work. So yeah, I have seen several employers, and this to me is the mark of a good employer, especially in the technology industry, who have specific protocols for just that sort of thing.
Right.
Many of them, especially for any kind of site, will basically go to HR and get approval. And if you do that, you're home free. They can't possibly claim breach of contract or anything like that, failure to provide duty. Sorry, the phrase, but if you don't, you make them mad enough. Because in these things, I usually like to bring up the steps that have to happen before you get sued. Here are the things that have to happen, and this works for any kind of lawsuit that have to happen before you get sued. Number one, you have to do something bad. Number two, somebody has to find out about it who has the power to sue you over it. Number three, they have to care. Number four, they have to be really mad. You know what the difference is between they have to care and they have to be really mad? $350 an hour. So it depends. If you developed Angry Birds, I know I said it. If you developed Angry Birds and they thought they had a claim on a multi-$100-million property, they're going to root around until they find a way to try to get it. Very, very likely. The employers I have had would not, for the most part, because they would do things like that. But there are lots of employers who would, and they might not even be wrong. That's an ethical question as much as it is a legal question. But if it's just something that you wrote and they find out about it and they're like, oh my God, he made $15,000 last year with his calculator app. That's ours. Yeah. Lawyers aren't supposed to say that, but equity. What else? These are fantastic questions, by the way. I'm really enjoying my time. Yes?
Ryan got me thinking. What I've done you get the employment agreement, and they're usually we own you, and I've been pretty successful having my lawyer write a letter that says, except for these things, please sign here.
Sure.
Even at the big Oracle, when I went to work for them, they said, yeah, we don't care about dog agility software. We're happy to let you develop that and own it. Is that the best way to handle this?
It is a very good way. Best is contextual.
Okay.
It is a very good way. I mean, I had employees come to me all the time when I was a GC and say, I want to do this, I want to do that. Or potential new employees, well, I have a little business doing this, doing that. Put a rider on your employment agreement. That is okay. Now if you come to me and you say you're operating the world's largest porn site, and I want you to write apps for my company that does financial software for churches, we have an issue. You may not be breaking the law, you probably aren't, but I can't have somebody finding out because you tweet on Maine that you think you're tweeting from super porn and you're really tweeting from John Jones, developer for holy financial institutions. No, we can't be having that. That's too much risk. By and large, absolutely. Come to me, tell me. If they are like, oh no, we can't do that, you probably don't want to work there, to be honest. Because I know for a fact that there's a very, very, very large commercial operating system and software manufacturer that's headquartered on the northwest coast that has an actual protocol for doing exactly this, and it's what I just described. So yes, it never hurts to ask. Fundamental rule: everything's negotiable. Oh, yep.
We kind of touched on this when you first started, though, about the situation where there might be copyright infringement, and the other company will, I'm not getting this right, the Goliath versus David.
Mm-hmm.
And you may feel, or you may have standing in that, but you don't have the money to pursue that. You're kind of like...
There are organizations that might be able to help you. First and foremost, one of your options might be a contingency fee agreement. where, if I take your case, and I'm not a litigator, so it probably won't be me, but, if a lawyer takes your case and says, you know what, normally this would cost you 30 grand, I'm gonna do it, you always have to pay the cost, by the way. It is literally illegal for me to pay the filing fee on your copyright infringement case, unless you pay me back. I mean, I can advance, I can pay it out of my court check account, but in most cases. In some cases, it's not, it depends. There's way, you can go to the court and ask for a waiver, whatever. But by and large, you always have to pay that. But otherwise, you can say, you know what? It's not gonna cost you a thin dime unless we win. And in that case, I get 30%. That's option number one. If you've got a solid case, lawyers will fall all over themselves looking for that one. Second option is, especially if it's an artistic thing or something that's, traditionally viewed as more important and to society than commercially, there are organizations like Lawyers for the Creative Arts, which I do volunteer work for. I just signed up with them. Who, you're a small artist, you wrote a little song, and Hershey's put it in one of their jingles, but they won't pay you. Obviously, there's some contingency possibilities there as well, but you're a little songwriter on the back streets, with nothing to your name. Go to a pro bono association like Lawyers for the Creative Arts, somebody like that. I offer free consultations for small creators and independent artists all the time. I can't go to court for you without some money behind you. I don't do litigation that much anyway. But if you come to me and say, I have a problem, I don't have any money, they stole my work, or they're hassling me, I wrote a little story and now, Harcourt is suing me, what should I do? I will probably, for a very low fee or nothing, write you the, go jump off a short pier letter to Harcourt and deal with it. So yeah, you have options that way, but by and large, yeah, otherwise it's all about the money. Sorry. It sucks. And it's something that lawyers talk about all the time too, by the way. We've all got horror stories. I had a client, really, really good friend of mine, known him for 20 plus years, has a little side business now, and he wanted to name a product something that happened to be the same name as a very famous entertainment group, we'll say. Has nothing to do with them. They had no trademark registrations in any class anywhere close to it. And in fact, both names originate from a common cultural heritage. He tried to register the trademark for his goods. They sent him a cease and desist. Comes to me, what should I do? I said, I can win this. I can win this. I can, they sue you. As close as lawyers ever get. In fact, you're my friend. I'm going to guarantee. But I need $25,000 to do it. I got to hire experts. I got to do a survey. I got to do all kinds of stuff. Do you have $25,000? I didn't say that to him because I knew that would be cruel, but I said, and I don't think you want to commit that. He's like, no, I don't. You change the name. They had absolutely not a leg to stand on. Ridiculous. But they were, multi-zillion dollar entertainment group, and he was a little dude with a shop in his garage. Yes.
Oh, I was
I'm
just fixing
sorry.
my
A hand raising.
Well, I have had a question in the back of my mind. Let's say it's real. I mean, months ago, I gave a talk at the technical conference inside the company, my company. It's not part of my job, but maybe it is, because we were encouraged to speak and evangelize, blah, blah. So I prepared a presentation with visuals, with narrative, screenshots, and everything. So let's say I've been thinking of bringing it here, to present the exact same talk here. Theoretically, can my company come after me? Because they think they own
come
my
after
work.
you for telling me about it. I don't know. That is perilously close to actual legal advice. I would have to know a lot more about your actual job and what the presentation was about in relation to what it is. I think that by and large, they would be very foolish to try to get to you to stop you from doing it or to be angry about it.
Falls within, they have to care for it.
Right, yeah, we're still in like step 2. They have to find out and they have to care. So, if you wanted to be absolutely safe, the thing to do would be to go to either HR or legal and say, that great presentation I did because you asked us to do, the broadening, evangelizing stuff. I'm a member of a local software group, I'd like to show it. If they say no, and you think about it, how hard is it worth arguing? Is it worth potentially my job because now the HR person thinks I'm a bad person? If they say yes, you're home free.
And the sequel to that question is, okay, I gave the talk. What if I sent the actual PowerPoint file to everybody?
It depends on exactly what's in it. At that point, if I was their lawyer, you and I would be having a talk you would probably not enjoy. Because I need to know what's in it and how closely related it is to our actual business practices, procedures, and processes. Because if there's anything in it that's even remotely close to competitively important information, you're in trouble. I have no idea what was in it. For all I know, you just gave a talk about some new kind of programming method. Here's why we should switch from Scrum to Agile or back or whatever. Whatever you're doing. But it's not related to your actual company's, what you do.
Not quite.
If it's just that, if it's just like, here's this new programming method, we should adopt it, or here's this new programming method, it's awful, don't bring it in here. But it has nothing to do with your actual company, it's probably okay. I'd still ask. But if there's anything that's like, because we developed, X kind of software, here's why Scrum is perfect for us, and then give examples of your actual development cycles, yeah, don't do that. You kind of see this continuum that I'm walking back and forth on.
So it's really anything that Leap could give the competitor an advantage, basically.
Anything that could possibly be competitively important. Now we're getting into one of the IP things that I didn't talk about, which is trade secret law. And anything that could affect competitive advantage, that could give your company a disadvantage if it becomes known, or give a competitor an advantage if it becomes known, which philosophically are the same thing, but legally slightly different constructions. Now we're into trade secrets, and disclosing them could be legally actionable, even without an employment agreement or a handbook that says don't do that. It'd be much harder without those things. But there are some basic expectations that everybody in business has, which is that you owe a duty of good faith and fair dealing to your employer, and that you won't, for example, leak their competitive secrets. So, yes.
I do a lot of side contract work, and a lot of it is just kind of general development hiring, but they'll have me create products for them. But it doesn't specifically say anywhere in it that it's work for hire or that it's their property. It's just that they are hiring me to do development work.
You own them. They, depending on the exact situation, first answer is always it depends. But if they're just like, this guy, he sends you an email and he says, hey, Jake, write me a this, write me a that, whatever, do this little thing for me. And then he sends you a check when you're done. And there was nothing more than other you saying, fine, that'll be $500. He probably has an implied license. Almost certain has an implied license to use it for what you reasonably expected him to use it for. So if you try to sue him for copyright infringement, that will be very difficult. Suppose he tries to license it to somebody else, or he tries to sell it.
Yeah, that's what I'm more curious.
Especially if he tries to sell it, then he gets the letter and says, by the way, you don't own that. You cannot sell what you do not own. So you need to send them to me if they want it. And if he says, well, but I paid you. You paid me to write it and I wrote it. That's all you paid me for.
Okay.
So yeah, your negotiating position is stronger than you might believe.
Wonderful.
Now, in the interest of good faith and fair dealing with your clients, I might suggest that you find a friendly copyright attorney and work up some kind of very simple, especially for small stuff, standard development agreement, or even just a work order system, where it spells out, who owns what. The only risk with that, and I've seen this happen sadly, is it can rock the boat. He may think he owns all that stuff. And if you go to him and say, no, you don't, from now on you have to either pay extra or keep in mind you can't sell it, he may just say, to heck with you, I'm moving to the next guy down the road. It's a risk. I've seen it happen. But especially interest of protecting both of you. 2-3 years from now, if this thing has legs, he sells it for an appreciable sum of money and you find out about it, suddenly you're not going to be friendly clients anymore. There's going to be an argument that could have been avoided. And by the time all's said and done, at that point, out of the $500,000, I'm going to get 20% of it, which I'm happy, but you guys didn't need to give me 20% of it. You could have kept it for yourselves if you had worked out in advance. Very, very old saying in medicine and the law. You can pay me a little now, or you can pay me a lot later. All the same people. And again, not trying to sell myself too hard. There's lots of very competent copyright attorneys in the world. But if you're doing that kind of work, I couldn't tell you how many smaller clients I have just written a standard development agreement, standard content license. I have a client who makes some wonderful video games, who has a musician who writes all music, the atmospheric music. I wrote it's literally just a little one-page thing. And it says, here's what I can do, here's what you can do. With artists especially, of any kind, especially visual artists, but sound artists as well, a lot of them want to be able to use stuff for their portfolios. Technically, that's a violation of copyright if it's a work for hire or they assign it to me as a company. But if an artist came to me at one of the computer game companies I work for and said, I want to put the splash screen that I just did for the new version on my portfolio, is that okay? I signed a little thing that said they acknowledged that I still own the copyright, and then I said, go for it, knock yourself out. Can't do it until I ship the game, obviously. But otherwise, sure. I didn't care. My bosses were very moral people, and they knew that that's how art works. Not a problem. So yeah, you're actually sitting kind of pretty right at the moment. Anybody else? I mean, I obviously love to talk. I just, I'll do it until somebody throws me out of here. But yes.
Can you just go into like derivative work a little bit?
A derivative work is what would otherwise be an independently copyrightable work that incorporates part or all of a previously protected copyrightable work. So there's two pieces. It itself has to have some independently copyrightable stuff. If you just take your work, and I mean, obviously there's a continuum here. Maybe you just change the color of the cover if it's a book or something, but you don't do anything else. Is that a derivative work? No, that's just a copy with a purple cover. Nobody's fooled by that. But if you take the book I wrote, and you go through and insert your own new chapter between every chapter that I wrote because you felt my story was too fast-paced, or you wanted to add your own unique spin on what the characters were doing, when I had the door closed. Fine. Now your thing is a derivative work. It's more than a copy. You've incorporated what could be your own protectable work. Here's an interesting thing that not a lot of people realize. Derivative works are themselves protectable by copyright, but if the derivative work contains infringing material, you can't register the copyright. The Copyright Office will not acknowledge it, which means it's very difficult to sue if you come up, like you took my 10-chapter book and made a 20-chapter book. 10 chapters of original stuff, which independently would be completely protected by copyright. Somebody takes your 20-chapter book and starts selling it, infringing what would otherwise be your copyright, you can't sue them because your work is illegitimate. Now there's all kinds of exceptions, guarantees. That's something that doesn't, a lot of people, if you ask them to think about it, would say, well, it only makes sense that if I add new stuff, I should be protected too. If you license that book from me and came out with the authorized behind the doors version, you have your own copyright, you're gold. Both of us now actually sue them. But if you just stole my stuff, even if you then added your own independently protectable stuff otherwise, your rights are very limited, by and large.
And to build on that too, and I, as the original author that you derived from, I still would be able to get a remedy from you then?
Oh, absolutely. I can stop you from selling your derivative work. If you then pull your 10 chapters out, and for whatever reason they're now free and clear of copyright, trademark, whatever, Lanhamax stuff, then I can't stop. But you can say, well, I added all this stuff. I don't care. Take my stuff out. That's the problem. I don't care about your stuff. Which is very common. That sort of question comes up a lot if you are familiar with something called fan fiction, which is a big deal. There's a major motion picture that got released this week that was based on a Harry Styles fanfic. I kid you not. And of course, everybody knows about Twilight, which is a 50 Shades of Grey fanfic, with all the serial numbers filed off in a new coat of paint. And it's a thing that happens, and it's very important to many creative sectors to do fanfic. A lot of creative rights holders, including people who own Star Trek, J.K. Rowling, who owns Harry Potter, are by and large okay with fanfic as long as you don't cross the line into commercial exploitation. They could totally shut down your WordPress site on why Harry should have ended up with Ron instead of whoever he ended up with. But they won't unless you start selling it, or otherwise actively damaging the value of their works. If you're Star Trek fans, and I know Star Trek fans and a room full of programmers is a stretch, but I'm just going to say, you may have heard of something called Exonar, which was a fan-made series based on Star Trek universe. Didn't reuse any characters, didn't reuse any ships, didn't reuse any planets, but it was still the United Federation of Planets. It was clearly based in the Star Trek universe, and Paramount sued the bejesus out of them. They tried to argue. They were basically arguing that that they should be able to do this under fair use and other theories. It didn't get anywhere. The potential liability was staggering. They didn't actually make it to a court decision. They settled and they pulled it. But it was one of the stronger attempts that I've seen in a long time for somebody to try to make fan fiction, very organized fan fiction, and make a strong argument that they should be allowed to. It didn't work.
Were they trying to sell it?
What does sell mean in this context? Were they trying to sell DVDs of their Exonar episodes? No. Were they trying to put them on YouTube and monetize them? Yes.
Okay. Because there's I've downloaded Star Trek
And the
movies that have been done with Star Trek characters that they seem to even have Star Trek actors in them.
The ironic part is, part of what sunk the Exonar people was that they were too good. Paramount was afraid that people would believe that Exonar was canon, that it was part of the official Star Trek universe, and that it would take away their control over the property. So they had to fight it. Whereas, if me and my little brother, borrow somebody's camera phone and reenact, the lightsaber duel from Empire Strikes Back and put it on YouTube, we might monetize it. Trust me, nobody cares. Yes?
What about something like Andy Warhol painting Campbell's soup cans? It's basically like a duplication of their work. Of the label and all
Andy
that.
Warhol and other similar, pop artists, reuse artists, we call them mashup artists now because everybody thinks they've rediscovered the wheel in every generation. Are arguing that their use is transformative. And if your use is sufficiently transformative, the work is no longer a derivative work at all. It is a new work, which happens to resemble the old work in some ways. It also could get to questions of fair use, and into questions more recently, and this came long after Andy Warhol, what's called the parody defense, which is not literally a fair use defense. It is a separate defense. Who here knows the difference between parody and satire?
Parody and what?
Parody and satire. I'm so glad none of you raised your hands because you'd all be wrong. From a legal point of view. From an English class point of view, you might be dead on.
Parodies, Weird Al Yankovic.
Sometimes Weird Al's work is parody, sometimes it's not. And sometimes he writes original work as well, of course, but parody is taking a work and making a derivative work of it that uses the derivative work to comment on the original work. The seminal case was a group that some of you may have heard of called NWA, who did a cover of Roy Orbison's classic hit, Pretty Woman. Roy Orbison's song is about a man who's lonely, who sees a woman that he thinks it's really kind of creepy in a modern, we don't like stalker sense. But at the time it was very romantic. It's about a man who sees a woman walking down the street and thinks, if I only had a lovely girlfriend like that, I'd be happy. But no, I'm alone, I'm sad, I'm going to go home. And then the end of the song is, oh, but she turns around and they're going to interact and maybe there's a chance for love to bloom. NWA recorded the song over again. Now the musical arrangement was quite different because they did their own music, although the beat and the melody were still very similar. They changed, I think, like 3 or 5 words of the song. The literal words of the song were almost identical. Clearly a case of copyright infringement, right? No, they argued that the way they sang it, the words they chose to emphasize, the pauses they inserted, even the tone of voice when they said certain phrases, what they were commenting on was, that's a stupid, schmaltzy song, and nobody should like it. Artistically, it is bad. It's like the sarcastic man on Saturday Night Live. He's saying exactly what you said. He's just saying it to indicate how stupid you are. Obviously, Roy Orbison's label sued them, and what shocked everybody was NWA won. They said, the court said, especially in America, in other countries, this is not guaranteed to work. But in America, under the First Amendment, we have the right to comment, to offer scholarly review and criticism of any work of art. A parody is basically a very, very close approximation of a scholarly review of an artistic critique. That's parody. Satire is when you take one work and you use it to comment on something else. So when Weird Al, I believe he does a version of Black Hole Sun, where he's actually making fun of the song Black Hole Sun, because these emo screamer kids, what the hell's wrong with them? That's a parody. Then he has another song, and the first one that pops into my head is Amish Paradise, which is a satire using the song Gangsta's Paradise, but he's not commenting on the Gangsta's Paradise song. I mean, that one's kind of on the fence. You could claim that he's talking about how silly it is to talk about gangsters, they might as well be Amish. Maybe or maybe not. But he's really commenting on something entirely different. He's just using the same rhyme structure and musical arrangement, especially, of another song to talk about how silly Amish people look to the English. So that's the difference between parody and satire. Here's the other difference. Parody is protected, satire is not. Satire is potentially copyright infringement. You could still get into fair use and a few other questions. But that's why Weird Al always gets permission. Even though when he knows when his song is like, the most famous recent example is his parody of Lady Gaga's Born This Way, which is called Perform This Way. And if you haven't seen it, it's hysterical. The video is amazing. But his song Perform This Way is, as you watch it, you can see he is literally making fun of Lady Gaga and her entire artistic oeuvre, or however you say that word. And that is clearly a parody. Other songs, not so much. Again, if you haven't seen it, you should watch it because it's hilarious.
There was a well-known court case with George Harrison. The Chiffons took George Harrison to court because they thought his song, My Sweet Lord, was similar to He's So Fine.
Yep.
He lost the case, but one of his finer top 40 hits came out of it. And I think on Saturday Night Live there was a parody of the whole courtroom scene with Eric Idle in it. And
If you want one, I don't know how many of you guys are 80s kids like me, but another one that really surprises people is Ray Parker Jr. sued Huey Lewis in the News because he claimed that I Want a New Drug was too derivative of Ghostbusters.
oh, really? Mm-hmm.
Yeah, that case settled, so we don't know for sure how it would come up. But yeah, that happens all the time. Pet Shop Boys, another very famous case where they, in one of their songs, used the refrain, I never promised you a rose garden. which of course is itself a famous song. And they got sued, and they said, well, this is like a 4-minute radio cut, and we reused 7 words. Judge said, but that's the song. That's the essence of the artistic creation of I Never Promised You a Rose Garden. So they lost, and they had to pay up.
I think Led Zeppelin took a group to court called Little Roger and the Goosebumps because they did a parody Stairway to Gilligan's Island.
Yeah, which was actually probably turned, I don't know that case, but it probably turned out to be a satire.
What about an entity that would, takes like the melody of a song or some of the lyrics, and they change the lyrics, and they use it to promote their business?
Well, copyright-wise, that's neither here nor there.
The one I'm thinking of is, everybody knows Susse Lennox. They've got this whole thing on YouTube of all these derivative songs, like they do a thing to Uptown Funk. They call it a parody, and
Yeah, 'cause
their
I'm very
version is
told.
Uptime Funk because they're promoting that their servers have have good uptime.
Mhm.
But is that just a gray margin in there?
No, whether it's used for commercial purposes, as far as determination of copyright infringement, is completely irrelevant.
Okay.
For purposes of fair use defense analysis, it may be relevant, but not in the way you might think. For purposes of calculating damages, once you lose, it is extremely relevant, because the damages are, you have to make me whole. You have to put me in the position I would have been in, but for your infringing act. Well, my damages are, you didn't pay me my licensing fee. My licensing fee for Uptown Funk is $500,000 for unlimited commercial usage. Will that be cash, check, or charge? So that's where it really comes important, is after you lose, how much should you owe them? By the way, here's an interesting analogy from Right of Publicity. How many of you here have ever seen the Taster's Choice cans that used to have a picture of a very, very handsome man with kind of dark, short hair on it, and he's like taking a sip, and oh, it's so good. You ever seen that on the Taster's Choice? I don't think he's on there anymore, for a very good reason. He was a model who worked for a modeling agency. He signed a certain kind of release, modeling agency signed a certain kind of release for his right of publicity, to put his face on their ads. It was a time-limited release, and somebody at Nestle forgot. And they left him on there for 10 years.
Wow.
And he apparently doesn't drink coffee and never goes to the store. But eventually he found out about it. And he sued them for, your thing ran out. You didn't have the right to put me on your coffee. And you've been using me for 10 years and sold millions and millions of dollars worth of coffee. And Nestle came back with, well, we signed this, and that was innocent, and you really should sue your modeling agency. And they had all kinds of reasons, because there was a lot of money at stake. And none of it worked. And he ended up, I don't think he has to work anymore, at the very least. And now, I'm sure Nestle is a lot better about clearing their license rates. But that was a right of publicity question, that isn't even copyright. So it's certainly something that happens in all fields of intellectual property.
I have a
Yes.
question. I've been thinking about a project where I would be transmitting people's copyrighted works. And I'm wondering if I could end up falling into the Napster world. I assume I would need legal counsel I should have legal counsel
You need to talk to a copyright attorney. Not only for American copyright, but because of the new law that the European Union just passed, which has to do with all kinds of interesting things along those lines. Many things that otherwise might have been defensible in Europe no longer are. But when you say transmitting, not up there anymore, but transmitting falls under distribution. Distribution is an exclusive part of the copyright bundle of rights. Arguably, it is very difficult to transmit digital data without at some point having a copy of it. But it's not impossible. You could set up a system in such a way that you never actually had a copy under your control. But just transmitting it, you could still be liable because that's distribution. It's a lot harder to prove. Damages are much harder to get. It's not impossible. But
So
you
you'd
know,
have to get permission from the authors.
well, there's all kinds of ways. It depends on what it is. Who here knows what a PRO is? Performing Rights Organization.
BMI or SK?
BMI and ASCAP are the two big ones. And also, I can't remember Harry somebody, the big lawyer firm, account. Music has multiple rights. There's the musical arrangement, there's the lyrics, and there's the performance of any given recording of a performance. They all have to be cleared in different ways. But yes, just transmitting them, it's very, very difficult to, Spotify has to have a copy somewhere, or at least a copy they can read to send it to me. So for them to say, oh, we just distribute them, well, but where is it coming from? Well, that's on our server. We don't let other people into our server. They can't copy it to their computer. We just stream it to them. I don't care. You have a copy and you don't have a license. And the songwriter can sue them, and the arranger can sue them. And if it's a performance, a recorded performance, whoever performed it can sue them. I mean, those might all be the same person. Many bands write and arrange their own music and then perform it. But it could be three different people. There are systems, because of that, it dates back to radio, when radio was the main way that popular media got circulated for decades. There are compulsory licenses that you can get. Like if you have a band and you want to cover a song, the band or whoever wrote the song can't stop you from doing your own cover. You have to pay a licensing fee, which is fixed by law by the Copyright Office. But the Rolling Stones can't come along and say, your cover of Jumpin' Jack Flax sucks so bad, and you should never be allowed to play it again, and copyright infringement, knock it out. They can't stop it. So music is a weird, special beast. But whatever it is you're transmitting, I'm, again, not trying to advertise myself, but any copyright attorney, let me look at your system. I bet I can find a copy somewhere. And even if not.
I didn't mean just distribute,
No,
but
I know.
as, there's, you have the notion that someone says, yes, I own the copyright of this, and I'm giving you license to distribute it to people and charge them for it. Right? Maybe it's a subscription service, right?
Yep.
But if they turn out not to have,
And by the way, that is no defense at all. It's a defense to willful infringement. But it is not a defense at all to copyright infringement. I had a license any reasonable person would have assumed. And there have been cases where one of the members of a famous band allegedly granted a license, and it turned out that, like Steve Perry walks up to you and says, hey, do you want to license a Journey song? You're going to take his word for it, right?
don't do that.
Don't do that. That's just an example, not to smear anybody in particular, but, at that level of course he has the rights. No reasonable person would assume for 1 second that this license was anything but totally legit. You're going to get sued for copyright infringement, and you're going to lose. Because he can't give you what he doesn't have. And he didn't have the rights. If you watch, I don't know if you guys ever watch the music channels on cable, but on the 80s channel, especially when they show songs, they'll show like little factoids. And one of them that I saw the other day that I obviously didn't know was Rod Stewart in, I want to say like 1986, sold his entire catalog to a venture capital firm. All the rights to all of the songs and all of his music up to that point sold to a venture capital firm for like $15 million, which might have been a great deal or might have been a horrible deal. But it's just funny to think that you'd think Rod Stewart, oh, he can license me, Maggie or whatever. No, he can't. He doesn't own it. He sold it to Venture Capital Inc.
We should probably wrap up.
Okay. It's all right.
No.
Like I said, I'll let us talk.
That was awesome.
Yeah, that was great.
Yeah, thank you.
Good stuff,
Thank you
Mark.
very much. The questions were wonderful.